There's a great deal of harmonisation in the world of IP. And so if you were coming to it afresh, you'd probably conclude that there are many similarities between European patent law and the law we have in the US. But actually, if you just scratch below the surface, you find there are some enormous and very significant differences. In the UK, within Europe, applicants would typically file a first application in the home country. And the same is true in the US. You would normally file a US application first. And then you have 12 months in which to kind of complete the formalities in any other country around the world that you choose. The problem is that the way that the law is applied in those different countries is well, I was going to say subtly different. In some cases, it's not so subtle. There can be drastic differences between the laws in the US and the UK and in Europe. And waiting to the end of that 12-month period, it's really too late. So you need to anticipate those differences in the first application you make, whether it's in Europe or whether it's in the US. And if you don't, you know, the best situation is that you're going to expose yourself to a whole lot more costs and frustration. And the worst case is that you'll end up not getting rights at all in that other place. So a big problem faced by US applicants when they come into Europe is that they're used to a system in which there's a lot of flexibility about the terms they've used to describe an invention, and they're entering into a system where those words are looked at much more critically. There's much more scrutiny of the wording you've used, and that's particularly problematic when you want to make an amendment. If you need to amend the claims of your patent during the course of the application process to make it allowable, the European Patent Office examiners are very strict as to what they will allow and what they won't allow as an amendment. And basically the test is the amendment has to be directly and unambiguously disclosed in the application as filed. And I think US applicants are often quite surprised at the strictness of that approach, ultimately leading, again, if they're not prepared, to not getting the rights that they thought they were entitled to or that they hoped for. So, you know, when we talk about international patent protection, there's no such thing as an international patent. There's still country-by-country patents, and you need to choose carefully. It's really being aware of what the differences are at the outset and building strategies into your application to deal with those differences and not leaving it until a later stage when it's really too late.